Today we're going to talk about IRS Form 4180 responsible party interviews. Listen, this is one conversation that can seriously create personal liability. An IRS Form 4180 responsible party interview is not routine. It may look like a simple questionnaire, but it's actually a structured interview used to determine who becomes personally liable for unpaid payroll taxes. And what you say in that interview can define the entire case that follows. Hi, I'm David W. Klossing. I'm a duly licensed tax attorney CPA, and I'm the owner of the tax law offices of David W. Klossing. To date, 24 offices, 11 states. Today I'm going to explain what IRS Form 4180 is really all about, what the IRS is trying to prove, and how to avoid damaging admissions in the process. So what does Form 4180 actually do? Form 4180 is used in payroll tax investigations. It's specifically used to determine who was the responsible party for payroll tax decisions and whether that person acted willfully. These two elements, responsibility and willfulness, decide most trust fund recovery penalty cases, and that's what they're going to hit you with. So, how does the IRS go about defining responsibility here? Responsibility is not based on title alone or ownership alone. The IRS looks at who controlled payments, who decided which creditors were paid and which weren't, who managed payroll, and who had authority over financial decisions. Even non-owners can be considered responsible if they had real control. We're going to talk about why willfulness is the real risk here. Willfulness is the second half of the case, and it's broadly defined. It doesn't even require bad intent. It can include just knowing that employment taxes were unpaid and choosing to pay other expenses instead. Statements like, "we were trying to catch up," can become evidence of willfulness. You need to understand this interview is very dangerous. The Form 4180 interview creates a record, and that record can later be used to assess penalties against you personally. Casual answers, guesses, or adopting someone else's narrative can create admissions that are very, very difficult or impossible to undo after the fact. There are some common mistakes to avoid here. The biggest mistakes include guessing about facts, overstating your authority, understating your actual knowledge in a situation, or trying to help the IRS by explaining too much. Statements about who made payroll decisions, why late deposits were made, or why other creditors were paid instead of the government. These statements could directly support the government's case. So what are your rights during this type of an interview? Well, first of all, you have rights. You can choose to have representation, and frankly, you're an idiot if you don't. And in most cases, if you request to consult with a representative, the interview must pause while you get representation. That protection matters. Why? Because once answers are recorded, they shape any following investigation. So what happens after the interview? After the interview, the IRS may issue a proposed employment tax assessment. This often comes as a letter 1153 or a Form 2751. This is where personal liability becomes real and deadlines become crucial. So at closing, if you've been asked to complete a Form 4180 interview, this is a critical moment in your life. At the tax law offices of David W. Klossing, our dual licensed attorneys and CPAs prepare clients for these interviews. We prepare them to avoid unnecessary exposure. Call 1-800-681-1295 or visit klossing-associates.com to schedule a confidential, reduced-rate initial consultation today. Be the best decision you can make in this situation.